Okay, I think that we can get started. Good morning and good evening to those of you joining us from different time zones. And thank you again for joining us today. We hope that everyone is having a good week and that you are all healthy, which is the most important thing. Today, we have the honor of having the participation of Ana Josefina Clement from Ernst & Young, who will tell us about the regulatory changes that we are seeing in Panama, and will also talk to us about the new private registry system for ultimate beneficial owners of the Panama entities. As many of you know, OMC Group has over 65 years in the industry of experience. And if there is one thing that we can say with certainty is that there is constant change in this industry. In the past few months, we have seen considerable changes in BVI, Nevis, Belize, Bahamas, and Cayman, to name a few jurisdictions. And as you can imagine, changes in Panama are very important to us. So we want to make sure that we are keeping you informed. We have received countless inquiries on this subject, so we thought that this webinar would be of great interest to our clients. And by looking at the list of participants today, I see that we were not wrong. So thank you again for joining us. Without further ado, let me introduce our panelists for today. And I apologize that Luis Ocando will not be able to join us. Ana Josefina Clement is the manager and the leader of the legal practice of Ernst & Young Law in Panama. She's a lawyer with over 15 years of experience in the legal field, focusing her practice on corporate, commercial, and labor law. Since joining Ernst & Young Law, she has participated in multiple corporate restructuring projects and has advised important multinational acquisition transactions. She has also participated and analyzed the regulations related to anti-money laundering and terrorist financing. So we're very pleased to have Ana today with us. Thank you, Ana, again for joining us. At the end of the presentation, everyone will be able to ask questions using the Q&A button on the bottom of your screens. And we'll try to answer all of your questions. If we're, for any reason, probably time constraints, unable to do so, we will get back to you via email with the answers to your questions. So without further ado, welcome, Ana, and we can get started.
Good morning, everybody. Thank you, Karina, and thank you, OMC Group, for having us today talking on such important matter as the register of beneficial owners in Panama is for us right now. This is it's a private and unique register for the UBOs of legal entities in Panama, which has been recently enacted by a bill as part of the government effort to strengthen the M&A and financial terrorism regulatory framework in Panama. Panama has been, the first time Panama was grade listed was in June 2014, and back in those days, the issue was exactly that we didn't have the proper regulatory framework, an absence of a regulatory framework that comply with the set of standards of the Financial Action Task Force, or GAFI, as we know it in our jurisdiction for the French name. And as a result of that first time that we were grade listed, Panama enacted the Bill 23 of 2015, by which it was properly developed the need of implementing the due diligence of every client we have in Panama. For this purpose, we're gonna focus our speech on resident agents. Nevertheless, resident agents, being the lawyers and law firms that constitute legal entities in Panama, are not the only regulated subjects of this law. We have financial and non-financial, and resident agents are regarded within the non-financial subjects that must comply with this law. In February 2016, Panama was excluded of the gray list as a result of this proper regulatory framework. Nevertheless, then again, in June 2019, as a process as a result of the monitoring process that is implemented to review the recommendations that FACT or GAFI has for all this jurisdiction, Panama was included again in the gray list. This time, it's not mainly because of the absence of the proper regulatory framework, but to the implementation of such regulations, and especially because of the exchange information that must be guaranteed and that has not been properly guaranteed in the eyes of GAFI or, well, as we know it in this jurisdiction as GAFI or FATF. And as a result, also, once you are listed, once you are gray listed, the Council of the European Union includes the jurisdiction that has been included in the gray list as a non-cooperative jurisdiction for tax purpose. And for that reason, we are unfortunate right now in that situation, but the government is working hard in taking all the necessary changes and all the necessary steps to make sure that we will soon again be excluded from the list, as this is a process that it's a contest process. We are supposed to have soon a peer review, and in such peer review, they will enter to confirm if what has been done is good enough to once again be excluded from the gray list, and that is what is expected because the changes has been important and the government has been doing what it's necessary for such purpose. And one of the decisions that the government have passed, one of the initiative is exactly bill number 129 of March 17, 2020. That is the one that we're going to be talking about, explaining what it's about, that creates the ultimate beneficial owner register. This register has the intention that every corporation, any legal entity constituted or registered under Panamanian law must, additional to the requirements stated in Bill 23, 2015, you have the obligation to disclaim the ultimate beneficial owner of the legal entity. Understanding that the ultimate beneficial owner is an individual, never a corporation, always a natural person that directly or indirectly own, control, or have significant influence in the decisions of the corporations. We have criteria to determine the condition of ultimate beneficial owner. The first one would be the equity interest or the number of shares, participations that the natural person has within the legal entity. That for financial persons would be 10%, based on a 10% acquisition. And for non-financial, that would be the case of the resident agents, would be a 25% participation. Control, understanding by control, exactly the significant influence of this natural person in the decisions made by the corporation or the legal entity. It can be also understood for the foundations, for the private foundations, and any other circumstances in which you can determine which is the natural person which makes the decisions and has the control. It's not easy to determine the ultimate beneficial owner, and it's the responsibility from our clients to disclaim such names. And from the resident agent part, not only to identify the person as the client state, but also to request the support documentations by which we would verify the information that has been granted by the client. And also there's a responsibility to keep this information duly updated. Under this new law, there are two parties under obligations. The resident agent itself, the resident agent can be an attorney, a single attorney, or a law firm which has constituted or registered the legal entity at the public register. This is a public information. So once you get into the public registered database, you can know for sure who's the resident agent for the specific legal entity you are investigating. And that is the parties who should in first place comply with this new law. Also, there are obligations for the legal entities or the corporation itself that would be to give the proper information to the resident agent. So whatever it is registered under this new register is correct and can be verified. The access to this register is limited, and this is a very important fact. It is not a public register as it is to compare with the actual public register of Panama, in which anyone can access and get the information that has been registered. In this case, it's limited and it's private, and it's limited to the resident agent itself, but just for the corporations or legal entities which the resident agent has registered, not any other, and to two officers that we have signed by the superintendency of non-financial subjects. Other than these designated persons by the law, there would be no other access granted to any other person, because while the bill was being prepared, one of the most important issue that always came into discussion was the importance of the confidentiality and reserve of this information. And one of the measures, besides the technological ones, was limiting the access of this information to these people that I just mentioned. This information would be given to certain authorities, under determined procedure that has to be previously complied by these authorities in order to the officers to give the information that has been requested. These authorities would be the superintendency itself, the financial analysis unit, that in our case for the Spanish name, it's known as WAF, the public registry, the Ministry of Commerce and Finance of the Republic of Panama, and any other government institution dealing anti-money laundering or financial terrorism matters. Then again, they would not have direct access to this register, but they can have access to the information through the designated officers once they comply with the established proceeding that has that has to be determined by regulations. Then again, this was very important throughout the discussions because it's very delicate information, and we understand that. And the purpose is to comply with the international standards and promote implementation of regulatory and operational measures, but without having this information to be known by other people that have no interest. The resident agent in first instance should provide the following data. This is the information that is strictly listed in the bill, in Bill 179. For the individual, it would be the full name, the personal ID, an address, a date of birth, a contact information, and the code of the financial analysis unit. And this part is important because prior to the registration in this new ultimate beneficiary owner register, you should register under the financial analysis unit. So you would have a code that would let you register to this new register. If you don't have that code, you won't be able to register at this new register. So that was planned this way because they wanted to make sure that the registration at the WAF, which is right now required, to enforce that legal requirement, they did this. For the corporation, they will require the full name, the folio number, the data registration, the address, the contact information, and also the code of the financial analysis unit. This is for the resident agent. This is not for the legal entities, this is not for the corporations, but for the resident agent itself. In case of an individual, it would be a lawyer by itself. In case of a corporation, it would be a law firm. Regarding the registration data for the corporation itself or the legal entities, because this would include the private interest foundations. About the corporation, it would be mainly the same information that we currently have at the public registry, adding the main activity. And this is very important also because the intention of this is to know for what purpose is a corporation being used. So the main activity is a very important data that must be included, and it has to be as exactly as possible within the operations of the corporation if it's an operative corporation. About the UBO itself, you will have to give the full name, the ID, passport, or any other ID number, the date of birth, the nationality, the address, and the date on which the person became the beneficiary. Because the purpose of the register is that they would have a backlog of this information, and if there's any change of beneficial owner, it should be registered as such because the information must be kept for at least 5 years. So in case there's any changes, the authorities would know which be the prior ultimate beneficial owner of the corporation, if that's the case, or if it hasn't been changed during 5 years or more, then you always have to keep it that way. You wouldn't have to change. Nevertheless, if there's any change in the information of the ultimate beneficial owner, the resident agent and the client itself have the obligation to keep that information updated, not only in the due diligence format that they're currently having in their office, but also in this new register. Even though the law established exceptions for declaring natural individuals or natural persons as ultimate beneficial owners, Bill 179 includes corporations listed in its stock exchange, state or multilateral entities, and legal entities in which a state is partially owned by a state. And even though the law understands that in those cases you won't have an individual natural person as a UBO, there's the obligation to register them in this new register for the purpose of knowing their existence. And in that case, the information that you can appreciate in this screen would be the one that has to be registered. Then again, in these three cases, you won't have to list a natural person because it is understood that that's not a possibility. Nevertheless, it would be also included in the register because if it's there any exchange of information requested by international authorities, Panama government understand that we must have this information and we must be able to give it if it's requested under the proper channels to give this information also. Well, basically, the terms, they're very important. One, the corporation is constituted in the public registry. You have 30 business days following the incorporation to get the registration done at this new register. The same with the updates. Then again, the resident agent has the obligation to identify, verify, and keep updated the information. Once the client informed of any change in the information that was previously registered, the resident agent has the obligation to register such update within 30 days following the date on which the information was received. As I mentioned previously, any information that is registered must be kept in this database for no less than 5 years after the registration of the dissolution of the legal entity in the public registry. And resignations are related to the resident agent itself. If the resident agent had identified that the information that the client has given is not exact, or for some reason it is not duly updated, or if the resident agent has not been given the support documentation required for verifying the information, the law established the obligation to resign as resident agent of this legal entity of this corporation. And as a result of his resignation within the term that the law established, this corporation or this legal entity will be dissoluted after the term is completed. So that would be the term established by the law for the purpose of the registration at this new register. Sanctions are established for both the resident agent and the legal entities that do not comply with this new bill. In the case of the resident agents, those are fines up to $5,000 for each legal entity that is not registered, right? It's not a single fine, but it's a fine for each legal entity that is not recorded. Also, the law established daily progressive fines, which are equivalent to 10% of the original fine imposed. And then again, it's regarding each legal entity that is not properly recorded. And in this case, the law established a maximum of 6-month term to apply this daily progressive fine. In the event of false declaration of the registered information of the beneficial owner by the resident agent, they will double the penalty. This would be the case in which a resident agent is part of registering information that he knows for a fact that is not exact. That would be up to a judicial process, and after that, then once the false declaration is proven, then the fine would be double. In all of the above, all these sanctions, even though they're established and they must be paid, won't keep the resident agent from the obligation of requesting and completing the registration at the private register. Then again, if for some reason the resident agent is not able to keep this information, to verify this information, to keep updated this information, the resident agent has the obligation to resign. As to the corporation itself or the legal entities, the law established the suspension of corporate rights, also known as strike-up, and as a result, no act, document, agreement, or any other document will be registered at the public register, and no certification will be granted regarding such legal person, except if it's for a specific reasons contemplated in the law. The intention of this would be that being the certificate, the good standing, being the good standing certificate, the document that is regularly requested as part of due diligence elsewhere in a lot of jurisdictions. The purpose of not giving this certification would be exactly that when in any other jurisdiction they request a good standing certificate from a Panamanian legal entity, the person won't be able to grant it, as the public register would not issue such certification. And in that case, that would be a red flag in the other jurisdiction to take into consideration. And then again, no act, document, or agreement will be registered. So in that case, for example, if there's going to be a change of director, for example, you won't be able to register such change of director, just to give an example, or any other transaction within the public registry would be subject to registration. The suspension of the corporate rights can be reactivated within 2 years following the date of registration of the suspension, after paying the fines, obviously. So you have a period of 2 years in which you can reactivate the legal entity for operating purposes. After these 2 years of suspension, without verifying the compliance of the registration or the payment of the fine for the reactivation of the legal entity will be dissoluted for all legal purposes. So basically, the consequences for the corporation start with the suspension of the corporate rights and will go until the dissolution of the corporation itself if it's not reactivated within the term contemplated in the law. Effectiveness of this law, This law is dated from December 2020, 2019, I'm sorry. So the law established a 6-month period for the superintendency to make all relevant measures for the management of this register. So we understand that they're currently working on this, and they're supposed by September 2020 to have completed the all the technological requirements and all the data base development to establish this register. COVID situation obviously has been a delay for such reason. Nevertheless, the first capture of the information by the resident agents is established within the law 6 months following the notification made by the Superintendency of Non-Financial Subjects in the national media, and this should happen by March 2021. Then again, COVID situation, I suppose, can have an impact on this terms, and if in any case, if an extension is going to be granted, that would require a statement by the legislative branch. So we'll be up to that, but by now, the date for the first capture would be March 2021. Then again, this is not information, this is not a new information for the resident agents, because remember that, as I stated in the beginning, Law 23 from 2015 already established the obligation of the resident agents of performing the due diligence or the KYC form, in which this information is already captured and should already be given by the client, not only for the form itself, but also with support documentation that grants the security to the resident agent that the information that has been identified can be verified. And that's the reason that why they would ask for a passport, they would ask for, in some cases, for a bank reference letter, in some cases for the share certificate. You have to give support documentation for the verifying process. So the information that has been requested in this new register is not new, it's not something from scratch. Actually, resident agents already have this information, that what the new or the intention of this register is not because Panama does not have the information, but is to make sure that Panama can give this information in a timely manner when exchange information is requested by international authorities. But then again, right now, all legal entities constituted or registered under the Panamanian laws, they already have to comply with this obligation of giving the resident agent this kind of information. And I'm sure this is by now, it's a standard in any serious law firm or in law itself. And the new provisions will be having to register in this private register. Then again, the sanctions that I mentioned for the resident agents, those are new ones. The resident agents have already sanctions established in law 23 of 2015. Nevertheless, these ones would be new ones. This one will be new ones. And definitely the sanctions they established for the corporations are also new. Those are not contemplated in the 2015 law. Eh, and that's the reason why all our clients must make sure that the resident agents that they have designated at the public register, whichever it is complying, or if not, take proper measures to change your resident agent and make sure that the resident agent that you have in given this service is compliant with all these new requirements that this new law established. And I don't, that would be all, Karina, for now. I guess we might have a few questions that we might answer. And
Yes, Anna, we have several, so we can get started with the Q&A. Thank you so much for sharing all of this information with us. I think it's a lot of information to digest, but we do have some questions, so let me get started with those. Okay, so I think you touched a little bit upon this, but can you let us know a little bit more about the dates? So when does this take effect? By when do you expect the beneficial owners to be uploaded into this new platform?
it's supposed, according to the law, Karina, according to the law, it's supposed to be by March 2021, the first capture. Nevertheless, then again, the effectiveness is established for 6 months following the notification of the Superintendency of Non-Financial Subjects in the national media. So that's kind of on an uncertain date, but it's supposed to be from March 2021,
Okay,
the first capture. Yeah.
perfect. So March 2021 is a key date for us then.
Yes.
Okay, perfect. So what would happen with companies that have been dissolved in the last 5 years? Will the UBO information need to be registered as well, or will that only apply for active companies? What about
That's-
that are being dissolved in 2020, so in this year?
No, that's a very good question. And the answer would be yes, it only applies to active corporations. This obligation is only for active corporations. The one that has already been suspended or dissoluted are not part of this new register. They would have their own situation at the public register, in which, as I mentioned, no record whatsoever can be done for corporations that are under suspension or obviously dissolution.
Okay, great. Thank you, Anna. What about the platform? Can you tell us a little bit more about the platform? Do we know who is developing it? Is it ready? Do we know any IT requirements, or do we have any information on that?
No, not really, Karina. EY has worked with the government in some areas, mostly in technical part of the FATF standards, but our participation has been mostly technical, and we are not informed about the platform. Nevertheless, we do know that the government is taking all the provisions necessary to make sure this platform is secure, and that this information would be reserved, and confidentiality being one of the key part of all this project. That is definitely the government intention.
Priority.
Yeah.
What about
Definitely.
the Panama Foundation? jurisdictions.
And let me add, Karina, as you mentioned in your introduction, this register already exists in other jurisdictions. So they're trying to keep
Replicate.
it, to replicate and keep it as close as other private jurisdiction that has adopted this register. So I think that would be kind of the guideline.
Okay, perfect. I think that's really important because this is a question that we get a lot. People are concerned about security, IT security, and I think it's important to know that the government is taking all appropriate measures to ensure that the information is secure and that it's being kept well. What about Panama foundations? So are Panamanian foundations required to report the ultimate beneficial owner as well, or how does this work?
Yes. Actually, the law it's for all legal entities constituted under the Panamanian law. For the limited liability, that it's not that important or it's not that different because you already have that information at the public register. So that would be the main difference, I would say, but they also have to comply with this law. And for the private interest foundation, yes, you will also have to disclose the ultimate beneficial owner of the foundation. Yes, definitely. And in this case, as I mentioned, it's not easy to identify and verify the ultimate beneficial owner. It's not an easy task. And the resident agent has the legal obligation to do a proper due diligence to identify properly the ultimate beneficial owner. Because as you could appreciate, there's sanction for him, for the resident agent, if a false information is given.
You raise a very good point. Can we go back to the fines, the sanctions and the fines? Which sanctions are for the agent and which sanctions are for the entities?
Well, the sanction for the resident agent itself are fines. The fines would be from $1,000 to $5,000. Important, very important to understand that would be for each entity that is not duly registered. For example, if there's a breach of, I don't know, 10, then times 10, times 20, times whatever and number you did not duly register. And that can be additional to the fine, that fine can be daily progressive until you comply with a maximum of 6 months term. In that case, there's a maximum. False declarations are also subject to sanctions. And there's the part that's important because then again, stating it once again, it's not only the obligation to identify, but also to verify. And this is very important, Karina, to understand. And that's the reason why your resident agent will request support documentation. You don't, it's not good enough to identify, you have to verify. And for such purpose, you will need support documentation that can give you that verification. And additionally, you have to keep it updated. According to
Yes.
law.
That was my next question. We have a question exactly about that. How often we will be required to update this information?
Okay, the term for that, the answer for that question would be not in this bill, but in the one I've been mentioned regularly, that is the 23 of 2015, in which annual update is requested in case of PEP, special jurisdictions, and political exposed person, I mean by PEP, specific jurisdictions. And remember that this is based on risk. So it would depend on the risk you have identified in each client, the regularity in which you should update the information. But the law only required annual updating in these cases, special jurisdictions and political exposed persons, and it's up to each resident agent or obliged subject to state within their manuals, their risk manual, how frequently they're gonna do it. Regularly, I may say in practice, they've been doing it every 2 or 3 years at most.
Okay. We have a good question here. So what happens if we fail to report changes in the UBO within the 30-day time frame? How can we remedy this situation?
Well, that would be a remedy that has to come from the resident agent itself. Remember that the resident agent has the obligation to resign in case you are not having the information you are requesting. All right. Ideally, your client should notify you these updates. That would be the perfect scenario in which me being the legal entity, I made any change. I contact my resident agents. I notify these new update, and the resident agent goes and registers the update. But if it's not the case, remember that the resident agent already have the obligation to keep updated this information. So for example, if you have a client that you have identified high risk and you will be doing a annual updating, then you would have to update within that term. If you have decided you're going to do it every 2 years or every 2 years, then you have to do it within such time space. If not, then again, the resident agent has the option, and I might say the obligation, to resign, basically to avoid the sanction. Basically to avoid the sanction. Yeah. So yeah, that would be something that would have to come from the resident agent in case the client is not proactively updating the information, which is the ideal scenario.
Okay. So can you tell us a little bit more or clarify the situation with companies that are listed?
In the stock exchange, you mean?
Yes.
Okay.
So companies, do they need to identify an ultimate beneficial owner, or how does that work?
No. The corporations listed in the stock exchange are one of the exceptions for having to declare ultimate beneficial owner as individuals, because it is understood that they have a numerous individuals as stakeholders. Nevertheless, there is some information that must be registered, and as you can see, I go back to the page, to the corresponding page. That will be the full name of the corporation, the address, the country of incorporation, and the name and jurisdiction of the stock exchange in which the corporation has been listed. You don't have to have an ultimate beneficial declared, but you have to have the information within the register
of the company. Okay. Okay, so we have a good question here. What about Panamanian companies that have a trust as a shareholder? Who would be reported in this beneficial owner registry in the case of a trust being the shareholder?
That would be the same. That would be the same. You would have to do your due diligence properly, and you would have to go up until the individual that is the beneficial of the trust. The trust itself eh, has an ultimate beneficial owner, and you have to start from the corporation, and you have to do all the due diligence until you get to the individual itself. If it's a corporation, if the beneficiary of the trust is a corporation, you still have to go one more
Even if it's
step up.
a trust. Okay. Interesting. Okay. We have many other questions. A lot of them relate to Panama foundations. But here's one that I think is really interesting. And we've received several of these. So just to clarify, the 5 years that you mentioned, does this include companies that are administratively dissolved because they're inactive? Or how do you treat those 5 years?
Those 5 years would be counted upon the information that is recorded in the public register. If the corporation, the foundation, whatever, is active at the public registry, there's the obligation to register at this new ultimate beneficial owner register. If the statute of the corporation or their foundation within the public register is suspended or dissoluted, because those are the possible status, you won't have inactive, you would have suspended, and suspended for a reason. Then you don't have to go, you don't have to register at this new register. And the reason for this is because once you're suspended, you are on your way to a dissolution. And what this new register, the intention of this new register is to have accurate and timely information for exchange information. So if you are suspended, you won't be able, as I already mentioned, you won't be able to record any act at the public register. And most important for me, I think, is that you won't be able to have a good standing certificate. And it's a practice in most of the jurisdictions when you do a due diligence to require a good standing certificate of the corporation, you are doing the due diligence. So these corporations won't get a good standing certificate from the public register, and this would have to be a red flag in the other jurisdiction to understand that it is a corporation that is not complying with the set of standards that promote effective implementation of legal, regulatory, and operational measures for M&A and FT. So that's a red flag. Please take note of this. If a Panamanian corporation or any legal entity is not capable of providing you with a good standard certificate, it's because it's been suspended. And if it's been suspended, it's because it's not compliant with this or other laws that also can take you to a suspension status. For example, the not paying the annual franchise fees is another reason that can take you to suspension status. So the importance here is to understand that whenever a Panamanian corporation cannot provide a good standard certificate from the public register, it's because something is going
Not
on.
right.
Yeah.
Okay. Thank you, Anna. We have another good question here. Again, many questions about Panama private interest foundations. So for private interest foundations, you mentioned that the resident agent must identify and report the ultimate beneficial owners. Under what circumstances, if any, should these foundations also report the protector and or the foundation council?
No, you don't have to. If they're not the ultimate beneficial owners, there's no need to disclaim the protector or the foundation council. It's information you already have at the public register, but in the case of the protector, you won't have to disclaim. Then again, it's only the information that it's stated in the law by now that it's taxative requested in the law. You don't have to give additional information, not for the registered purposes.
Mhm.
That doesn't mean that your resident agent in its due diligence process might require additional
Of course.
information if for some reason the resident agents think that this is necessary to complete the due diligence process. Then again, it's a process that is done under risk basis. So it would be up to each resident agent the need of additional information if necessary. If not necessary, you don't have to give it just
Okay.
because.
And what about second or third beneficiaries in succession line? Would these need to be included?
I would say it's not stated as such in the law, so I would say initially that no. The second or the third option, I would say no. I would say that what has to be registered is the initial beneficial. The initial beneficial.
Okay, I think we have time for one last question, and this one has come up quite often as well. Can you tell us a little bit more about the requirements to get this information from the public registry? So you mentioned that a competent authority must request the information. How will this information be shared to other countries? What is the process? Because we know that it's a private and confidential ultimate beneficial owner registry, but how does the request for information system work?
Well, right now, then again, Karina, this is the nuance is the register itself.
Mhm.
But currently, Panama, as well as the rest of the jurisdictions, are subject to exchanging information with international authorities when requested by the proper channels. In this case, the law will establish the mechanisms by which these authorities would request the two persons that has been designated by the superintendency for the information. The most important part that was discussed when preparing this law was exactly what would be the reason why you would request this information. Because you have to have a reason and a reason based
Valid.
on, yeah, you have to have a valid reason to request this information. For such reason, in each case and for each authority, they would have to establish the reason why they request this information. And it's up to the superintendency to validate this reason and to give the information. If for some reason the superintendency understands that this information is not being requested for valid reasons, they do not have the obligations to give the information just because it's been required. They have they have the opportunity and the obligation to make sure that the information has been requested for valid purposes, that it's been requested by the proper authority, and that it's going to be used for special purposes and not for whatever reason they want. So that's the reason why that the that the access to this register was limited. And it's limited to very few persons. If you analyze, it's a very limited number of persons that will be dealing this database. Also, we'll have to see when the database comes out, but the purpose is that everything is encrypted, that it has the technological measures necessary to make sure that the information is properly kept. And remember also, Karina, that by March 2021, we also have the effective, it comes into effect, our regulations of personal data. So that would be a complement to this law also.
Perfect. Well, I think we're out of time, Anna. Thank you so much for sharing all of this information with us. We have many unanswered questions, and so we will get to all of those questions via email. Thank you everyone for participating today. And I hope you have a great rest of the day wherever you may be. Stay safe, and thanks again for joining us.
Thank you, Karina. Thank you, OMC Group. And well, it's been a pleasure, and hopefully we can answer the rest of the questions via email if you need any of our support.
For sure. Thank you very much, Anna.
Bye-bye. Have a nice day,
Bye.
everybody.
You too.
Bye-bye.